Yeah, I'd like to hear his presentation.
Yeah, I think Jay's got a, somebody will start with Jay, and then after Jay's done, we'll go to Jay.
There you go.
Easier on the back. Well, seems like we have found an area here that was overlooked. And I'd like to talk about the federal patent laws. I'm sure you know now that land above the gate is federally patented mining claims. So we'll start there. Federal land patent cannot be challenged by a state court because it flows from the United States treaty. And therefore the state court has no jurisdiction over title or ownership of such land. The U.S. Supreme Court has consistently ruled land patent certifies absolute and supreme title to the land, and any claims not presented during the patent proceedings are barred forever. There is no public roadway easement recorded on any of the patents on Hughes Creek mining claims behind the gate. Therefore, the easement you are claiming is unconstitutional, and furthermore, you have no jurisdiction over these properties, nor does any court in the state of Montana. If you continue to insist upon removal of the gate, you open yourselves up to not only a claim of unconstitutional violation of federal patent law, but a Fifth Amendment takings claim without compensation. It will require months, if not years, of court filings and arguments, but we are confident that in the end, we will prevail, and the taxpayers of Ravalli County would be on the hook for thousands or millions of dollars in damages because the Board of County Commissioners in 2019 chose to rely on Montana statutes and legal analysis of their county attorney advisors who failed to investigate or understand the legal issues presented to you today. And I'd like to talk a little bit about the patent process. Private property behind the gate on Hughes Creek are protected by land patents issued by the federal government pursuant to Article 4 of the United States Constitution and the Mining Law of 1872. Consequently, only a Class 3 court has jurisdiction over these patents. The 1872 Mining Act gave miners the opportunity to obtain patents entitled to public domain lands. The primary purpose of this act was to promote mineral exploration, development of federal lands in the western states, and offer an opportunity to obtain clear title to mines already being worked, and to help settle the West. And the federal government needed the gold and silver. Under the law, any individual, U.S. citizen, or corporation could explore federal public domain lands in search of valuable minerals, then stake a claim on that land. The 1872 Act prescribes the process for obtaining a patent in detailed statutory language. We have provided you with a copy of the statute. Rather than quoting the statute in legalistic 19th century language, given that you can read it yourselves, I will summarize the process in ordinary language as outlined in the statute. First, after meeting the requirements of locating and filing a mining claim in local jurisdiction and providing documentary evidence proving the working of that claim, under the law, the individual or corporation may file an application for patent in the proper land office. The application is made under oath and must show the minerals claim has been legally filed and must include a plat and field notes of the claim from the U.S. Surveyor General's office showing accurately the boundaries of the claim, properly marked boundaries. Before the applicant for the patent, the claimant must post a copy of the plat together with a notice of application for a patent in a conspicuous place on the claim. In addition, he must file an affidavit form at least 2 persons that such notice has been duly posted and file a copy of that notice in the land office. At this point, the public notice requirements are required to determine if there are any claims on the same property. A notice of application for patent must be published in the local newspaper for a period of 60 days. And the same notice must be posted in the proper land office for 60 days. When the application is filed, or before the 60 days expires, the applicant must file a certificate from the U.S. Surveyor General's Department that $500 of labor and improvements have been made upon the claim, and that the plat is correct with description, natural objects or permanent monuments to identify the claim, and must prove an accurate description to be incorporated in the patent. Once the 60 days of publication have expired, the claimant shall file an affidavit showing the plat and the notice have been posted in a conspicuous place as required. Then, if no adverse claims has been filed within the proper land office before the expiration of 60 days, it is assumed the applicant is entitled to a patent upon payment of proper fees. The Mining Act also outlines the requirements for adverse claims against patent applications. The claim must show the nature, the boundaries, and the extent of such claims. And within 30 days of filing that claim, the adverse claimant must commence proceedings in a court of competent jurisdiction and prosecute the claim to final judgment. Failure to do so is a waiver of adverse claim. According to the statutes and the settled case law on this issue, usage restrictions placed on land such as roadways, ditches, canals are to be spelled out in the patent. The rights inherent in patent land are carried from heir to heir, from heir to assignee, and assignee to assignee in perpetuity, forever. The law of a particular piece of patented land is governed by a congressional act or treaty under which it was acquired, or by terms spelled out in the patent. The United States acquired its lands by entering into various treaties with its former owner treaties that are still in force. As a condition to the admittance to the Union, 49 of 50 states signed enabling acts that formally ceded all unappropriated or not yet privately owned lands to the federal government. The land was then held in trust by the federal government until someone proved a claim on it. Then, pursuant to various land acts of Congress, such as the 1872 Mining Act and Homestead Act, the land was granted to the private owners by letters patent under the signature and seal of the President. By issuing such land patents, the federal government essentially transferred the rights conferred by the treaty to these individuals. The land patent is the highest title of law, is superior to any other deed, and is protected by treaty law. The same treaty law that protects tribal reservations. Article 6, Clause 2 of the U.S. Constitution states, "This Constitution and the laws of the United States which shall be made pursuant thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding." Can you imagine what kind of country this would be if the states could just go ahead and legislate law against federal, U.S. Congress and congressional acts? It'd be a circus. Federal land patents cannot be challenged by the state court because it flows from a United States treaty, and therefore, state court has no jurisdiction over the title or ownership of such lands. The U.S. Supreme Court has consistently ruled that land patent certifies absolute and supreme title to the lands, and that any claims not presented during the patent proceedings are barred forever. Well, I guess now, if you have that information in front of you, we can talk a little bit about the procedure for patenting a mining claim. Would you guys like to start with the heckler? That's the first one. The heckler is the first one where the gate is. That's mineral survey.
Could you clarify one thing real quick?
Sure.
When you were talking about adverse claims, you used roads, ditches, etc.
Right.
Where are you citing that from?
That comes right out of the 1872 Mining Act.
Do you have a section on that? Cause
I do.
I read this.
I didn't find that in the act.
Oh, dude. Okay, in section 2338, I think it's page 8, the bottom paragraph. As a condition of sale, in the absence of necessary legislation by Congress, the local legislation.
Sorry, Jay, I'm not with you yet. Section 2328.
2338, page 8, I believe.
2338.
2338.
As a condition of the sale, starts out.
That's right. In the absence of necessary legislation by Congress, the local legislative of any state or territory may provide rules for working the mines involving easements, drainages, and other necessary means to complete the development. And those conditions shall be fully expressed in the patent.
I heard you say roads in your opening, and I just, that was the word I was looking for, or I hadn't found it here, so, thank you.
So, if you have, mineral survey 5898 here, the information on it, I provided everybody with a copy of, some information that we had to get from Washington DC. And it's basically the process for the patent, procedure, and one of those is the posting and a certificate that the notice remained posted and that no adverse claims were filed. And that goes for every one of the claims, starting at the gate all the way up. Same procedure, no adverse claims. It's published in the newspaper. Anybody had 60 days, including Ravalli County, to state their claim, and they didn't. So, let's go to this one particular document here that I find really interesting. One that I've never been able to find in this courthouse. It should be in this courthouse.
Is this in the packet?
It is.
Where's that?
Well,
Under HECLA?
Yeah, under Heckler, it's about,
Yeah.
8 pages back. This is the beginning.
How much? Probably.
Yeah, it's 8 pages back.
Oh, here it is. Right there.
He is. He's a lawyer and he's a physician. Tell me what pill to
Kind of an
take.
interesting certificate
Have
of
you checked
re-examination of title to the Heckler mining claim. Was I, Howard D. Smart, County Clerk and Recorder in Ravalli County, State of Montana, do hereby certify that I have made careful search of these records, of the records of my office, and find nothing of record affecting the title to the Heckler Placer mining claim from the 20th day of December 1900 at 1:30 p.m. until the present date. Witness my hand and official seal this 14th day of March 1902.
I love the way they talked back then.
Oh, yeah.
I don't know,
Good English.
but I'm kinda thinking that a 60-foot wide easement running the full length of my mining claim affects my title. Now, another thing that's interesting, how come I've never been able to find this document in this courthouse? How come we had to go all the way to Washington DC? This could have resolved a lot of problems if we had access to this in our courthouse. Maybe we do, but I don't know where to find it. That to me, gentlemen, is strong language, that there is nothing affecting the title. And admission by the county, our own county clerk and recorder's office. You'll find a couple more of these on the rest of those claims up through there too, if you look through it. Same wording. So, you know, those old miners, this old guy here, he posed old John Humble. He went and filed a mining claim. He worked it for long enough to do his improvement work necessary. We filed for an application to patent. And so he posted this in the newspaper as he's supposed to for 60 days. He posted it on his claim for 60 days in a conspicuous spot. He posted it in the U.S. Land Office. The U.S. Land Office gave him a certificate. Right there. Kind of a copy of the clipping. We have some of the newspaper clipping on there. Where it was published in the Ravalli Republican.
I saw that.
Okay. That's an affidavit to prove that they put it in it. Anyhow, this certificate is from the U.S. Land Office. It clearly states that it was posted for the proper amount of time with no adverse claims.
Jay, do you have a copy of an adverse claim?
I do. I do have a copy of an adverse claim. So, let's go to the very back, and you'll come to the alpha placer. So the alpha placer,
You know which, number it is?
7301.
I think so, yeah, thank you.
I got everything by number.
Well, I got it right here. Just not smart enough to find it. Okay, the alpha placer. This guy filed for his application in 1905, Pete Bennett. That name sounds familiar, doesn't it? You've seen his name on documents before, haven't we? Anyhow, Pete and Mary, they filed for their application 1905. This is at the mouth of Hughes Creek, by the way. And everything was going along good with their patent process. They put it in the newspaper, they posted it in the land office. And then one day, during that 60-day within that 60-day adverse claim period, they get a letter from the forest supervisor. And he is writing a letter to the land office saying that he believes that this is not appropriate for a mineral patent. That it is more suitable for agriculture, and that this could be a town site at some point in time. It'd be better off to have a saloon or some other establishment that's not allowed on National Forest land. So it throws a wrench into gears. And it took the guy another 2 or 3 years to get his patent, just he finally got it, but it was a process where the land office had to go and verify this claim and investigate it. So the example of that would be, I believe it's this one right here. That's the right, same one?
Yeah.
Okay. That's his official complaint there. Not sure where it is at.
The original report,
Okay. Good. Okay. So the letter you're looking at there, Greg, is the president reestablished the boundaries of the national forest during that interim. Within like a month or two after he filed his complaint, Forest Service came back and said, we're retracting our complaint or our claim because we're no longer in the that place is no longer in the boundaries of the national forest, so we're retracting it. still didn't stop the land office from continuing their investigation of the claim. So, in essence, what they had to do is they had to send government prospectors out there to go verify that Mr. Bennett had minerals on his land. They found out he did, so later on he got his patent. So, 1872 Mining Act. Also talks about adverse rights, adverse claims. Let's go to page 6 of the 1872 mining law. First paragraph, section 2328. Okay, applications for patent for a mining claim, or for mining claims under former laws now pending, may be prosecuted to final decision in the General Land Office. But in such cases where adverse rights are not affected thereby, patents may be issued in pursuance of the provisions of this chapter. And all patents for mining claims upon veins, lodes, hereto issues shall convey all rights and all privileges conferred by this chapter where no adverse right existed on the 10th day of May, 1872. I would say that pretty much explains it. It kind of covers adverse claims and adverse rights. Anything to the contrary of what's described in that patent. So, if Ravalli County had a road there, if they had a road there, that's questionable too. We have all this information to show it never went past the gate, really. If it did, Ravalli County failed to state their claim during the comment period, so you're barred. Can't come back, the door's closed. I would guess the federal government did this for a reason. If they're turning over clear supreme title to the land, they probably don't want anybody coming back 6 months later, 120 years later saying, whoa, wait a minute, we got a claim on this ground. Wait a minute. No, you don't have a claim. If you did, you lost it because you didn't participate in the patent process. You didn't identify that interest at the time the process was going on. So no, you're barred. Anyone's barred from any type of claim. So, I don't know if I gave you guys a copy of this. And this is just an example of what happens when state entities try to assert an easement over a piece of patented property. And this is a decision that was made by the Ninth Circuit Court of Appeals in the state of California. I'm going to read the decision. California, at this late date, asserts its public trust easement over petitioner's property. When the petitioner's predecessors in interest had their interest confirmed without any mention of such easement in the federal patent proceedings. The interest claimed by California is one of such substantial magnitude that regardless of the fact the claim is asserted by the state in its sovereign capacity, this interest must have been presented in the patent proceedings or be barred. Ninth Circuit Court of Appeals. No, you got to participate in this patent process. And if you didn't, game over.
What was the state of California asserting they had a claim to, Jay?
They were claiming that they had a water easement, a way to travel with a boat or whatever through the waterways of this patent, which is another interesting question. springs to mind. I wonder where the stream access law comes into play under federally patented land. Cause they barred them from a waterway easement. Still an easement.
Yeah, they talked a lot in this about water for mining claims in this act.
Right. So,
Do you have copies of that, Jay, for this guy? For those guys?
oh yeah, they can have this. Thanks. Pass that around, I guess. So, here's another one. We got another one. This one has to do with the Indians. They claim they had a right because they lived here for hundreds of years. Well, Supreme Court found that they didn't state their interest, or the federal government didn't represent their interest during the time the patent proceeding took place, so they lost their interest. So these interests had to be addressed at the time the patent process was taking place. And you can go on with it, there's case law after case law about it, I mean, I can stand here and talk about it, and every situation is different, I understand. But even people like out in the state of Washington that have patented land on coastal properties, and the local government comes along and says, you can't build here because coastal area is protected. They took it to the court, Supreme Court found it. Their state statutes didn't override the federal patent, and they owned everything within that patent and had the rights to do whatever. That was, legal activity in their property, so, thank you. So, we've got the alpha placer here, right? Yeah.
Is there an area I can zoom out, or?
Well, let's just look at that date, 1904, that's when that was surveyed. Okay? Looks like we got a road here. Okay, well, I guess there was a road there in that day, huh? Let's go to the Heckle, which one is that? MS 5898. Okay, you see a lot of stuff here. This is 1900, June 28th of 1900, just a few days after they adopted the road, huh? This road that was completed and delivered to the county in good condition, that was the terms of the agreement. Nowhere on this plat do you see a record of a county road. You see excavations, you see shafts, got some more excavation work here, a cut. I don't see a road. I wonder how that guy would conduct his mining operation if the federal government guaranteed him he had the minerals from the surface down within the boundaries of that claim. How in the world would he be able to conduct a mining operation with a 60-foot easement going the full length of his property? Do you think that was the intent of the federal government when they issued the patent? No way. No way. Don't make sense. Let's go to,
Jay, is the Hecla placer where the gate is?
yes, sir,
Where would it be on that map?
right in this corner here. Let's go to 5883 or 5883, 5882, and 5881. It's all one survey.
There's 5881, is that it?
That's probably it. Okay. This one is the gym, and it butts up to the Hecla. Next claim up from the Hecla. You look at that excavation, looking, I don't see a road anywhere, I see a plume, I see a lot of mining activity and whatnot going on here. I don't see a road. Why would they record a road down on the Altiplacer and not record a road here if their government surveyors are recording everything? Seems kinda interesting to me. Let's go to Let's go to 585. 6,000, did you get that one? Okay. I think that's it. Okay, next continual mining claim adjoining the mountain guide, the discovery. And you see a lot of activity there, they got excavations going here. They show the creek, they show boundaries, they show some work that they did, some more excavation work. No road. No road there. Date on that? August 31st of 1900. The road is still, how come it's not there? So, that being said, I guess we could turn our attention to this board if you're interested. Okay. Had everybody been prepared, that goes for everybody, probably would have had time to round up all this wonderful information. That is public information. Let's go over here. This map is the first U.S. Geological Survey map of the area, taken in fall of 1899, October of 1899. Right there's the Alpha Post Office. About a mile, maybe a little further down the road from the mouth of Hughes Creek. That's the only information I can find on the location of the Alpha Post Office at that date and time. Okay, so on the map here, on the Forest Service map, we put it somewhere in this area right here. And we found a structure in this area around Cow Creek that we believe was possibly the Alpha Post Office at one time. So, let's take it back down. Shrink it down, please. So let's come up here a little bit. These three documents right here, these are mining claim filings on drainage. They're on Mill Gulch. We call it Mill Creek. It's now called Mill Gulch. These documents weren't available at the time, the 2017, before and after the 2017 hearing, because they were quarantined upstairs in the bat attic, as I refer to it. They had poison bats or something going on up there, and nobody had access to it. These three documents display the distance at the date and time. These old timers referred to the distance at Mill Creek or Mill Gulch to be about 8 miles from the mouth of Hughes Creek. On today's Forest Service road, it's about 6 miles. For some reason, there's a 2-mile discrepancy here between today's path and yesterday's.